evening, and it's a pleasure to be here. I am here in my capacity as an SEC board member, and so I will take 30 seconds of your time just to tell you something about the SEC Arbitration Institute, and which is that actually it is a very international arbitration institute. It had over 55% international cases last year. We also have very good numbers on diversity. Almost 40% of all appointments are female, and that is including appointments by the board, parties, and co-arbitrators, not only by the board, which is the usual statistic. And finally, there is a very interesting SEC report on construction, which actually compares construction disputes in Sweden over a number of years, ad hoc and institutional. And the report confirms that in Sweden, in fact, settling construction disputes by ad hoc arbitration is generally much more expensive and also lengthy. So with that said, I now turn to introduction of our wonderful panelists here today. Our first speaker is Aleksander Godhe. I hope I pronounced that right. And he's a research associate in dispute resolution at the Center of Construction Law and Dispute Resolution right here at King's College. He's also a visiting fellow at the Stockholm Center for Commercial Law at Stockholm University. He specializes in construction disputes, arbitration, and international economic law. And he also has particular interest in history, and I understand that it's not limited to history of arbitration, but more broadly. And today, Alex will talk about exclusion of evidence and how to strike the appropriate balance between the tribunal's discretion on the one hand, and on the other hand, ensuring due process. After Alex, we will now focus a little bit more on these issues of evidence, and our next speaker will be James Hope, who is a partner of the Swedish law firm Vinge. He's a dual qualified Swedish advocate and English solicitor advocate. And James has over 25 years of experience working as a dispute resolution lawyer. And he has also acted as counsel and arbitrator in over 100 international arbitration cases, which is quite impressive indeed. He started his career as a solicitor in Scotland, and then spent 10 years in London, after which he moved back to Sweden, which I understand you're currently based. Yeah. That's right. Now, in his free time, James likes singing in choirs, as do I, in fact, in a true Nordic Baltic tradition. Now, with Midsummer coming up, James, do you have any performances planned that we could attend?
Well, everyone's very welcome to come to Sweden for Midsummer, which is the best time of year. Yes, there's certainly singing. As well as dancing around loopholes and pretending to be strong.
In fact, I am leaving tomorrow morning at 7 a.m. to Finland for a midsummer deliberation. Let's see how that goes. James will talk about document production, a topic that often elicits deep sighs, I think. It's fair to say, especially if one gets a 400-page Redfern schedule in a construction case, but nonetheless, it is a very important topic which can sometimes break or make the case. And James will speak in particular about the relevance and materiality to dispute of the requested documents. And he will also take us fishing. So stay tuned. And last but not least, Lindy Patterson KC is a full-time independent arbitrator and adjudicator with 39 Essex chambers here in London. She's recognized as a go-to person for complex energy, infrastructure, and construction disputes in both civil and common law systems. She also arbitrates disputes regarding general commercial contracts and real estate, and she operates in many jurisdictions with a variety of governing laws, and is also being appointed by a number of different institutions, including ICC, LCA, DIAC, and others. Lindy is a chartered arbitrator. She's on FIDIC's president's list as a member, and also an honorary fellow of RICS, the Royal Institution of Chartered Surveyors. And one interesting fact about Lindy is that she enjoys hiking. And the last hike, if I remember correctly, was actually quite close to where James is, but not quite, by the Arctic Circle in Norway. Very well. So, and Lindy will cover the approach of the tribunal across both civil and common law systems to issues of burden of proof and the weight of evidence. So without further ado then, and considering that it's quite late in the evening, we will do our best to keep you awake. And I will give floor to you, the audience, for a couple of questions, maybe one or two immediately after each presentation, just simply to engage you. And Alex, the floor is yours.
Right, thank you very much, Eva, for the kind introduction. So the context for this presentation and this paper is the observation that not all evidence should be included to the record in arbitration. And there's quite a bit of talk, a bit of literature looking at the specific circumstances where this is the case, for instance, privilege, confidentiality, or illegally obtained evidence. But what I will try to do in this talk is take a step back and look at exclusionary rules of evidence as a standalone concept in arbitration that really brings together all these various circumstances in which evidence should not be included to the record, be it either at the disclosure or the admissibility stage. So by way of background, this topic is arguably one of the areas of friction between legal systems, but I would definitely say or suggest that although common and civil law have different rules, very much the outcome of the application of these rules tends to be similar. Legal privilege is a relatively good example. Legal privilege is primarily a duty of confidentiality of the legal representatives in civil law systems, not to disclose certain documents, but in common law, it is very much also a principle that relates to the actual documents themselves. Now, arbitration is, of course, special. It is not bound by these various domestic principles. So, building on the idea that Jan has made in the earlier panel, perhaps we are seeing a bit more of an emergence of a transnational approach of lex evidentia in international arbitration. And if that's the case, I would suggest that discretion, procedural discretion, is really at the heart of this system. So I would like to first very briefly look at discretion, then turn to duties of tribunals, consider the evidentiary test in the context of evidence exclusion, and finally try to set out the different circumstances in which evidence should be excluded. And if you're interested, there's a paper forthcoming on this subject in the Stockholm Arbitration Yearbook at the end of this year, I believe. So I do not want to go through the entire slide, but just to wrap it up and say that discretion is really found in all the various sources of law in arbitration. And both the arbitration rules and the arbitration laws, they have quite little variation between them in this context, but they really give rise to two very important principles. And the first one is that tribunals enjoy broad and discretionary procedural authority, and they provide very little guidance as to what exactly does that mean, what should the tribunals practically do when exercising this discretion. But then they add that, oh, this discretion is limited by the principle of party autonomy, which is quite surprising in some respect, in the sense that parties would very rarely exercise the power and exercise this autonomy to dictate how tribunals should approach evidence, but never say never. It's possible in some circumstances, for instance, if the parties were to adopt the IBA rules as binding, and in that case, well, perhaps the IBA rules are a bit more prescriptive in the context of what evidence should and should not be excluded. So that would be a notable exception. So this topic is really all about dealing with discretion. And well, what does discretion mean? And in principle, and brushing aside all other principles in arbitration, discretion means that tribunals can take any considerations into account that they deem relevant or persuasive, any at all. But of course, this is limited by the application of duties of the tribunal, which have two very important functions. On the one hand, they would give us the ceiling for tribunal discretion, so they would constitute the outer limit of what tribunals can do from a procedural standpoint, but also there would be more of a soft influence in the sense of they would guide how you exercise the discretion. And I think a more normative point can be made here that discretion that is completely unguided, completely ad hoc, is simply unattractive. It is quite arbitrary and could be unpredictable to the parties. So I would like to focus on just three main relevant duties in this area. And the first one is the duty to resolve the dispute, because of course the rationale for arbitration is the resolution of the dispute, completion of the mandate, and eventually the rendering of an award. And it provides that an award must be reasoned, taking into account party arguments, and apply the right law. Now, I would argue that by extension, you cannot resolve the dispute without evidence. So this duty to resolve the dispute should also compel the tribunals to uncover the truth, and therefore, to get to the bottom of the evidence, to include evidence as much as possible. So that, at least to some extent, explains why tribunals would rather include evidence if possible. Now, the cardinal duty in this area is the duty to afford the due process. It's also called procedural fairness or natural justice, and it really sets the outer limit for discretion. Now, the way due process works is it has various manifestations, so it's really an umbrella term for a set of other principles that come into play. And I would just like to look at two of these manifestations of due process, and the first one is the right to be heard. It becomes particularly relevant in the context of evidence exclusion if a party makes an objection to the inclusion of evidence. Of course, if the tribunal were to admit or include such evidence without discussing the objection, that could be perceived as a violation of the right to be heard. And conversely, excluding evidence could amount to denying the party its due opportunity to present proofs and arguments. But I would also very much add to that due process does not mean that the parties have an unlimited, unrestricted, and infinite number of opportunities to submit evidence. There is a cutoff somewhere over there that the tribunals should enforce. The other dimension of due process is equality of arms. It provides that a party must not be under conditions that place it at a substantial disadvantage vis-a-vis the opponent. And it's quite an interesting element of due process, because it has been said that it means that evidence illegally obtained should be excluded. And many tribunals look at that and say and exclude illegally obtained evidence on this ground. Of course, due process is very, very important to this area because it could be a ground on which an award might be set aside, although these challenges would quite rarely succeed in reality. And I think the sort of the sad consequence of this is that we see quite a bit of due process paranoia in the context of approaching evidence. But of course, the data does not support that at all. And finally, we have the duty of procedural economy and efficiency. This is the duty that I would argue leads to quite a bit of evidence exclusion. So, for instance, late submitted evidence would be a good example of failing to comply with certain directions that the tribunals might impose. And I think the big one here as well is relevance and materiality, which James will speak about a bit more in a moment, but I think it also stems out of the need to afford procedural economy and conduct the procedure efficiently and economically. So duties are something that tribunals should live and breathe whenever they take procedural steps, but they are, of course, by themselves, not an evidentiary test. They are not a box-ticking exercise that you can simply apply and, oh, due process is satisfied. It's something that is considered holistically, looking at what the tribunal does. So of course you can ask the question, well, what is the evidentiary test in the context of exclusion in this context? And unfortunately, it has to be some form of a balancing exercise in which tribunals would weigh in the different considerations, weigh the different interests and duties against the circumstances of their case and strike the right balance. So of course, this is a case-by-case exercise that mainly revolves questions of fact. But the types of circumstances that tribunals find persuasive, well, that's a really interesting area of arbitration. There's a lot of work that can go into it and looking, if you have privileged evidence, what are the relevant considerations that can persuade the tribunal? And of course, we have to bear in mind that duties would restrict and guide the exercise of this balancing exercise as well. One last thing to add in relation to the test is that, well, we don't have to be so binary in the context of what is the outcome. It's not just include evidence or exclude evidence. There's definitely a menu of options available to tribunals. So, for instance, a tribunal might include the evidence but order redactions, or include the evidence and order a certain cost sanction on a party, for instance, if it acted in bad faith, or take a series of other measures to strike the right balance again. So there's a whole menu of options there. Okay, so we have discussed discretion, duties, and the evidentiary test, but I guess the last question is, okay, in what circumstances does exclusion of evidence issues actually arise? And I would suggest that these rules of evidence, these exclusionary rules of evidence, should be divided into three different categories depending on the circumstances that would taint the evidence, that would bring exclusion into question at all. And these are three circumstances. The first one would be where the substance of the evidence excludes it from the record, for instance, or it's covered by privilege, or the evidence is simply irrelevant altogether. The second set of circumstances would be where how the evidence was obtained excludes it from the record, and legally obtained evidence is a very good example here. And finally, there's the non-compliance of the evidence with a procedural direction of the tribunal. So, for instance, late submitted evidence, evidence submitted after the hearing, or one that does not comply with certain, perhaps, language requirements as well. And of course, it's worth adding that a single piece of evidence could trespass on all three of these areas in the right circumstances. All right, so just by way of a quick conclusion, exclusionary rules of evidence, I hopefully have argued, are a standalone concept in arbitration procedure, and they really stem out of the combination of discretion and duties, the application of the two. And their application means that in some circumstances, evidence should be excluded. So I'll take a pause here. Thank you very much.
Thank you, thank you. Do we have any follow-up questions? Maybe we'll say, yes, there's a question. Wonderful.
My name is Jari Grigorian from the. Hi, my name is Jari Grigorian. I'm from the British Institute of International and Comparative Law. And I was wondering what the role of applicable procedural law is. So let's imagine that we have a contract with an arbitration clause. And then the question is what procedural law applies to obtaining evidence. And let's assume that relevant institutional rules or ad hoc rules do not have any detailed information on, for example, what to exclude and what not to exclude. I'm thinking about the situation, for example, when a dispute is governed by, well, is seated in a jurisdiction or otherwise is procedurally governed by a law which is not very familiar to the arbitrators. And they don't know much about what to exclude, what not to exclude. And I much imagine that domestic laws differ when it comes to what is admissible and what is not admissible. So this interaction between procedural, mandatory procedural rules and the discretion, any thoughts on that or any examples you can think of?
I would say it's the rule of evidence that's really relevant here is discretion, and all the various arbitration rules and laws would really pretty much repeat the same thing and not be prescriptive. I mean, maybe I can't think of an example where there would be a mandatory law that would be very prescriptive in this specific context. But as far as I'm aware, it would always be about discretion at the end of the day. And of course, the application of the discretion could be such that, yes, the tribunal will follow an approach that is more consistent with common law or with civil law, but to me at least, it is nothing more than the application of discretion in the circumstances.
Could I suggest an example? The parole evidence rule in English law, where if you were being strict in English law, you would exclude quite a lot of evidence, you wouldn't even allow it in. But you can imagine a situation in international arbitration where the arbitrators would allow it in, possibly in your example where they aren't very sure what the rule is. And you probably come to the same end result, but slightly messily. I was going to actually, if I may, I could just ask you a question, because something you didn't raise is the sort of lazy arbitrators approach where you don't, or the slightly frightened arbitrators approach where you don't dare to exclude evidence, but you simply give it no weight, or very little weight.
I mean, I'm not sure I would call it the lazy rule. I would say that is typically what happens. That a tribunal is very concerned about excluding evidence, so we would typically say it goes to the weight.
Yeah.
I was just thinking of some examples recently or over the last few years where I've had applications to exclude expert evidence on the basis that they are not truly an expert. This is quite a common one now. That they then cite lots of reasons why this individual is not independent, etc., and call on the tribunal not to allow this expert report to be received. It's a very brave tribunal that says, no, it may go to the weight, once they have heard these individuals. But it's quite a tall order, I think, for a tribunal to exclude.
Just to respond to that, simply changing the weight does not always address all the circumstances in which exclusion arises. I think a good one is if parties just keep submitting evidence, you have to, say stop at some point, simply saying, oh, we reduce weight, we include it, but reduce weight, weight, that wouldn't work. So it's an option. And if you go back to the menu of options that a tribunal has, absolutely the reducing sort of the weight of evidence is out there. But it doesn't address all the circumstances, I would suggest.
Yeah, I just wonder if there is a distinction between excluding evidence and this cut-off date that you're identifying. Basically, you're saying the time has come, we cannot allow anything more in. And I guess I don't really categorise that as excluding. I'm saying we've reached a point that you can no longer submit anything, and you're absolutely right. As a tribunal, you cannot allow things to keep coming in. Although I guess a party can make a submission as to why it's come so late. If they have good reason for that, no doubt the tribunal will consider it. But I agree, it's not quite as simple as saying everything must just be given a weight, as it were.
And I think just on that point that Lindy just made, I think it is certainly a very good tip from a practitioner's perspective to have these rules included in PO1 in the first procedural timetable, so that it's very clear what happens, with related evidence. You need to explain how come, and often tribunals include it, like extraordinary circumstances need to be at stake. And similarly, the cut-off date for submission of evidence, and I always add cut-off date for submission of evidence, except for expert reports and witness statements, because what is meant is, of course, just simply exhibits rather than last minute, 2 weeks before the hearing, an additional expert report. Once I had that, where the parties argued that, in fact, that's evidence. So here we go.
Can I suggest there's another issue which we come back to the question of level playing field was mentioned in the last panel, which is really interesting. And something that is related to what you're saying is the whole question of how long you entitled to cross-examine for. And in common law, in the common law world, you're entitled to cross-examine for as long as you want. there's a sort of idea at least, I mean, that's not really true, but there's a sort of principle that you shouldn't stop counsel from cross-examining. Whereas in the civil law world, I think after quite a short time, if it's not going anywhere, the tribunal may think, well, what's the point? And that's a real difference in playing field. I've seen it in practice, and it's can be quite awkward, particularly if you have common law lawyers sitting in civil law panels, and they don't understand the approach of the civil law panel, and they prepared for 2.5 hours, and the civil law panel thought maybe 15 minutes. Again,
or when counsel are in fact, from 2 different legal traditions. I just had that case, 3-hour cross-examination of one witness by common law counsel, and then comes the turn, the respondent represented by civil law, and literally 5 questions. Did you sign the document? Yeah, I know. Okay. And we were all like, right. After 5 minutes, the cross-examination was over. There was one more question from the floor, and then I think we need to move on.
David Waxman, I'm a judge. I'm very interested in what Alex was saying, I think what Godhe was saying as well, because actually now we don't really give unlimited time for cross-examination. Proportionality is what governs things. And Alex, you were talking about 3 particular types of exclusionary rule. But proportionality is hugely important, and we've had all the challenges in the court about this is a failure of due process, this contravenes Article 6 of the European Convention. We've had all of those arguments, and those arguments never succeed. And so I think there's a great virtue in arbitrators taking a proportionate approach to evidence. And they, from my point of view, as a judge who deals with arbitration appeals and applications, they shouldn't be scared of doing it, because actually, so far as the law in English-seated arbitrations are concerned, claims for serious irregularity very rarely succeed, and arbitrators are considered to be in charge of their own procedure. But it does seem to me that this notion of proportionality is very important, to the extent that an arbitrator says it's not that it's illegally obtained, it's not that in theory it's entirely irrelevant, it's just that it's disproportionate to allow it in. And there can be circumstances in which parties say, well, we want 10 experts. And the court, for example, is, well, you're not having 10 experts. It's not your inalienable right. You can have 3 experts, because that's all the court needs to deal with that particular issue. And so I think that arbitrators are well entitled to take the same approach. But I would certainly agree with the notion that you do your procedural orders in as much detail at the beginning, so as to avoid those arguments coming up later on.
Thank you. Can I just say thank you for a very, very useful comment, because what you have in the English court, of course, is the overriding objective, thanks to the law rules, which everybody since the reforms quite a long time ago knows about and hopefully follows. We don't really have an overriding objective in international arbitration, although many arbitration acts, if you think about it, do have something like it. And maybe we should be better at putting it in very clearly to say, by the way, this is what applies. And I think for example, the SEC, they change their rules to include efficiency. And I think we could make more.
Just very quickly at one point. So going back
You're the boss.
Sorry?
You are the boss.
No, at this moment you are presiding. I'm in your hands. But I just wanted to add something to what Mr. David said just now. I very much agree from the perspective of an arbitrator. And for example, I have precisely a case in point where a party put forward 8 witnesses, but basically more or less all saying the same things. So we said, look, you really have to limit this to 3. But I also want to sound the word of caution, however, also from an arbitrator's perspective, as in international arbitration, because again, going back to what Mr. David said, it is absolutely true that if you are sitting in London or in Paris, also in Geneva, you are very comfortable with the approach that the courts will take. And so you know very well that, look, if 8 witnesses saying all the same things, if I limit them to 3, Sir David, and PS will probably uphold the award, and there will be no issue at all. However, what if the award will need to be enforced, for example, in the country of the respondent, which is, not England, Paris, not England, France, or Switzerland, let's say, right? But it's a country where that the courts may be actually particularly sympathetic to respondent, who perhaps is a state entity, etc., etc. Now, as an arbitrator, you are clearly guided by counsel there as well, because your claimant's counsel should be alert to this kind of thing and not make kind of applications for exclusion of evidence if they think there is a risk. But to what extent you should be thinking about that as arbitrator as well, even if perhaps the claimant's counsel in the enthusiasm of the adversarial battle, things that they want to have, the evidence excluded and so on and so forth, but you have in the back of your mind that, concern that perhaps when the award goes for enforcement in that country, that can be a dangerous thing. I leave it as a question. I think it's a difficult thing for us.
Yeah, I think this is a very good point, and I think this is why so often we talk about the chess clock situation, the hearing protocols, so that somehow legal representatives realise if they're going to put forward 8 witnesses, they're running the risk that they're going to have far less time because of what's happening. It may sound trivial, but I think that sort of procedural requirement can limit some of these difficulties. I would include that regarding expert witnesses as well. And that again can be in PO number 1, but I would agree with you entirely, Renato, because we still have a situation in some regions where if witnesses do not take the oath in arbitration, the award may not be enforced. So there are many things that we need to think about, not simply from our viewpoint, as it were.
Thank you. Very well, James. Now, floor is all yours.
I think I'll go stand over here because it's easier with the slide. So we're going to move to a completely different topic, which is the question of relevance and materiality when it comes to document production. I think you've heard enough about me, but going on to the IBA rules on the taking of evidence, which hopefully are familiar to all of you. The part that I've highlighted is the key issue that I want to talk about. What you have to say when you ask to produce documents is that the documents you're asking for are relevant to the case and material to the outcome of the case. Now, what is difficult is that there's rather little guidance about what that means. And this is an international instrument, and it's interpreted, at least in my experience, somewhat differently in different parts of the world or by different people. So we're not entirely sure what we're dealing with. We're not even entirely sure whether we're dealing with 1 test or 2. And I thought I would try to elucidate a little bit about that. And as it happens, I have some case law to draw from 2 jurisdictions where I'm quite familiar. I started life in Scotland as a Scottish solicitor, and then I was here for a long time, but then I went to Sweden, and I'm now a Swedish advocate. And I've got, unfortunately in England, we have very little to go on here because the English courts don't deal with requests to produce documents, they deal with disclosure. So you don't get into this issue, you don't have case law on relevance and materiality in this context. But actually in Sweden and in Scotland, we do. So that's what I'm going to talk a little bit about. First of all, there is a commentary on the IBA rules of evidence, but it doesn't say all that much. It says that there was an attempt to have a balanced compromise between common law and civil law systems. And it says that obviously, if you're going to try to produce a document, you have to do so and put forward sufficient specificity so that the tribunal can understand the purpose of why you need the requested document. And that's the key point that I'll come back to. I'm also going to talk about fishing expeditions, as Eva mentioned, because that ties into this. If something really isn't relevant, then it becomes a fishing expedition. And you might ask yourself what that is. So let's turn to Scotland. Some of you may know the word haleutic, which means of or pertaining to fish. And if you were a barrister, you might make the submission that the other side's request for documents is wholly haleutic. I've certainly had that submission made against me, and it's quite an amusing little word to know. What guidance can we see from Scotland in relation to this question of fishing? I should take you back to the whole basis upon which the Scottish courts look at this, because they look at the whole question of a request to produce, or it's what everything has wonderful words in Scotland. So this is a commission and diligence, and it's a very special process within the Scottish system. But it's all tied to the averments in the pleadings, and that is the key point, because you cannot ask for a document unless you can tie it to the pleadings, and there's a lot of case law about that issue. That, I suggest, is something we really can learn from in international arbitration, because you can't simply say relevance very, very generally, as people very often do. You have to say relevance by reference to your pleaded case. And so you see in the Scottish courts, they say that a fishing diligence, this commission and diligence, so a fishing request, is one for which there is no basis in the averments, in the pleadings, or one which involves too wide a search among all the papers of the haver. The haver is the person who has the document. So too wide a search that goes beyond the pleadings, that is what is a fishing expedition. And then we see in Parks against Tayside Regional Council from 1989, a trawl will be launched and then the catch inspected in the hope of finding something which may turn out to be useful. That is, of course, very often what people are trying to do in their request to produce, possibly particularly in construction cases when you have these 200 pages or whatever. And I would suggest that we should try to be quite rigorous in working out what is relevant and what is material by reference to the pleadings. So that's a little lesson that you can get from Scotland. Turning then to Sweden, we also have a somewhat similar procedure in Sweden, that there isn't discovery or disclosure, but instead you have to request documents. And then the court or a tribunal can decide on questions of relevance, somewhat similar to the rules in the IBA rules. So we have this case from the Swedish Supreme Court in 2012 with the wonderful name of Flexi Boys. And there was the question about what relevance means. And they said that actually it was a case actually about a tribunal which ruled on relevance, and then there was a question that went to the courts about secrecy and whether there was a professional trade secret that had to be protected as a matter of law. But the issue of relevance was an issue that they touched upon, and they said, well, relevance is something that's quite broad. So the tribunal should be relatively generous in its determination of relevance. And the question of relevance is whether the document can be said to be relevant as evidence in the case. And again, that's a buzzword for looking at what the case is as pleaded. So is this going to be evidence which somebody is going to be able to use to prove their case? In other words, does it provide an evidential contribution to what's already there? And that's quite important, because we're not talking about just documents generally, we're talking about documents which actually will be evidence. And from a civil law perspective, Sweden isn't really a civil law country, but it's more adversarial, but it's got civil law elements. And from a civil law point of view, evidence is something that somebody needs to prove something. And so if a particular assertion is admitted, then no evidence is needed on that point. Now, the Germans, of course, we heard in the last panel, are much better at this than most people, because they're very rigorous at attaching from the pleadings to the facts. But we should all try to do that. So should we try to work out what actually is going to be evidence in the case to prove a point that is in dispute? And again, the court in this case touched on what a fishing expedition is. They said that a document request for the purposes of enabling the requesting party to determine whether to widen the scope of its pleaded case. That is what is called a fishing expedition, and that is not allowed. So what can we conclude from that? One thing to start with is that these two tests, relevance in the case and material to the outcome of the case, they're two separate tests. And I would like to suggest, but you may disagree with me, that they are quite different tests. The first one, the question of relevance to the case is quite broad, because relevance is often quite broad. Whether something is material to the outcome of the case is much narrower, because quite often you don't need all this evidence in order to affect the outcome. In fact, even if you were going to try to prove something because you thought it was relevant, if in fact that isn't going to help you in your case because for other reasons, for legal reasons or whatever, then it's not going to be material to the outcome. And as for phishing, well, we saw before what the test of phishing is. That's simply not allowed. The IBA rules don't talk about phishing, but I suggest that they include the principle. So you may want to have some tips about what to do when you do all this. And we've got some very experienced arbitrators in the room who can comment on this as well. First, I would say you should refer to your pleaded case. Again, the commentary to the IBA rules says that you should consider and explain the purpose for why you want the documents. Do that by reference to the pleaded case. If possible, ask for specific documents. Now, the IBA rules do say that. They say, first of all, you should ask for specific documents, but then you could ask also for categories. Most people forget about the specific documents and just ask for categories, sometimes very wide categories. That's difficult to deal with if you're an arbitrator because it's often too wide. The temptation is simply to say no. I've recently done one of these where the tribunal said no to both sides. Each side had 50 pages or something, and everybody just said no, 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 all the way along because the categories were too wide, quite simply. So try to keep your categories, if you need them, as narrow as possible. And I would suggest you can ask for several subcategories of documents. You might think that that's dangerous because you might not get them all. But I would suggest that if you're asking for categories, the chances are that if it's too binary, you won't get anything at all. It's better then to have some subcategories that are awarded than not to get anything at all. Remember, and this goes on to what we're going to hear from Lindy in a minute, remember the burden of proof. I would say you don't need documents where it's not your burden of proof. Well, you don't necessarily need documents. There may be certain situations where you might need them. But as a general rule, you don't need to prove it. It's for the other side to prove it. Remember also that in this world with tribunals, in international arbitration, the tribunal cannot compel the document production. In court, you can do various things to compel. Sometimes in arbitration, you can force the parties to go to court to assist the arbitration, and you can compel that way, but that's a cumbersome process. But in most cases, you can't compel. So you're left with a situation where you asked for something, the order was made, the documents didn't come. And then you just have to rely on adverse inferences. And it's important to think at the beginning how to do that. And the easiest way to do that is if you have rather specific documents. If you're just sort of saying, well, please draw adverse inferences because we didn't get all this category of documents, it's difficult to know what the inference is. But if, for example, you asked for minutes from 10 board meetings and you got them from 9, but not from the 10th, there may be an adverse inference to draw from the reason why you didn't get them from the 10th. The other side will say, well, it's because they don't exist, but can you really believe that? It may well be that, in fact, there's something that they want to hide from the 10th board meeting. So those are just a few thoughts on what is, unfortunately, quite a complicated and sometimes rather boring subject, but a difficult one and something we all have to grapple with. Thank you very much.
Thank you, James. Do we have any burning questions from the floor? Yes, please.
Matt Malloy, MCMS, and Arbitrator, Julie Case. I'd be interested in the panel's thoughts, and probably I think there's a crossover between the first exclusion of evidence and your talk, James, on disclosure and fishing expeditions. And it strikes me that it requires the arbitrator to have, I think, knowledge of the issues and the substantive case, and perhaps an idea of where they're going, and a knowledge of what they do know and what they don't know. And I think if they know and they're confident and it's informed, it might be easier for them to make decisions on exclusion or failure to, or a decision not to admit or concede to an application for documents. What I'm interested in your views is how much do you think that the structure of arbitration fetters the arbitrator's ability to take full advantage perhaps of that knowledge that they'll have through subject matter knowledge or technical know-how or particular legal issues?
I'd like to say one of the main problems, I would say, from experience of sitting with arbitration, dealing with that sort of issue, is that you come at this really quite early in the case. You're quite green, you don't know your fellow arbitrators so well often. It's the first time you've really grappled with the issues together. And equally, you don't want to poison the well, as it were, with the parties. So you don't want to be too controversial at an early stage. You want to keep the parties with you. You want both parties to feel that they have a tribunal that they can respect and like. And I think that fetters the tribunal quite a lot, because the tribunal often doesn't want to make the very bold decisions which maybe they could make. For example, well, of course, none of this is material because you're going to lose on the law, or whatever it might be. So in my experience, at the early stage, also partly because the tribunal doesn't know the case that well, tribunals tend to be somewhat timid. And then they fall back on procedural issues like, oh, it's too wide or whatever, which is a good way to go, but they don't know the case as well, or maybe are not prepared to deal with things as well as they should.
James, a quick follow-up question. Do you find that tribunals are sometimes possibly too reluctant to draw adverse inferences, and what is the extent of drawing adverse inferences? I'm thinking of the case where you have a reference schedule, you order a number of documents because you find that they would be relevant and material, and then you get the response from one party. Responsive documents do not exist. We discussed everything orally. No, there are no memos, no meeting notes, no WhatsApps, no, there's nothing. So what can a tribunal do in these situations? I'll answer my own question for the first step, which is, ask for an independent, not a detective, but an independent expert perhaps to review WhatsApps. I mean, that's really already going overboard, because essentially you're telling the party, I don't believe you. But first of all, what can a tribunal do? And if it's not much in terms of actually obtaining the evidence, because you draw the distinction between going before the courts, how far does the tribunal go with respect to drawing adverse inferences?
I think the reality is that tribunals don't, or very rarely would say in their award, we draw adverse inference X.
Exactly, and as a result, why? Yeah.
However, it's very often the case that tribunals do draw adverse inferences without saying that. And I think tribunals very often do that in this sort of example. A party who, for example, simply says, no, there are no documents, and it's obvious there are, runs the very clear risk of not having a tribunal who are with them. I can also tell you a story about I was acting for a client from a country in Asia, the country, it's quite a big country. And we were ordered to produce documents. We were told of instructions that the documents were confidential. Tribunal said that they wanted to produce them anyway. We still didn't produce them. And in those circumstances, I think it was very clear that the tribunal was against our client. They didn't say so in the award, but it was clear that we lost, and that they said something about how they thought it was very strange that we hadn't produced the document. It didn't help by the fact that the other side found all the documents on the internet. When we said that they were confidential, but that's part of the problem.
Perhaps the point James is making is that actually it's not an adverse inference that we draw, because you don't know what the adverse inference is that you're going to draw, but it sort of influences the whole flavour of the proceedings. Because I was going to pose the question, how many arbitrators have actually said in an award, as you say, I draw the adverse inference that such and such is the case because we didn't see a document. It's very difficult to do.
What I do think you can do there is ask witnesses. You can go back to this issue, and a very clever counsel will go back and say, by the way, you were, I don't know, the finance director or whatever, you signed off, you probably don't remember now, but a year and a half ago, you signed off on document the best way, you said there were no documents. Can we really ask you about that? And sometimes that can be quite an issue.
Very well. Lindy, then the floor is yours.
Okay, I am going to touch on burden of proof, standard of proof, because I think it's only when we start examining them that it's been interesting for me just to prepare for today as a reminder of the sort of things that we look at on a daily basis but don't always articulate, and weight of evidence, and really, I guess, how a tribunal approaches it. So first of all, I just wanted to talk about burden of proof. I think it's already been said this evening that parties will almost invariably not agree how they're going to deal with burden of proof or who bears it. Now, you might say, well, it's pretty obvious. Anyway, it isn't always. And we know that UNCITRAL and CTAC expressly deal with burden of proof. And I've identified on the slide the articles that provide that, where it says each party shall have the burden of proving the facts relied on to support their claim or defence. Now, many of us might think, well, why do you need to say that? Is that not just, stating the obvious? Probably because we all live with this generally accepted principle that regardless of legal system, the burden rests with those who make an assertion, or they who assert must prove is perhaps another way of doing it. But there are some distinctions that I think we can draw. And I think these are, for example, you may have legislation that you're proceeding under, which will dictate which party bears the burden. The party may have determined, for example, that all that they need to do is to make certain assertions and then somehow argue that the burden of proof has shifted. I think it can be challenging in some of these circumstances, and what I wanted to do actually is to identify a couple of examples in my experience. But just to take as an example, we usually see a respondent arguing in a defence that the claimant has failed to discharge the burden or onus of proof. Therefore, end of story, the claimant loses. What I would say is that all a respondent needs to do? Or does a respondent also require to make competing assertions of fact that they're offering to prove, so that the tribunal is faced with these two competing sets of facts? I mean, I've seen it played both ways. I've seen respondents who've stood firm and simply said, claimant has failed to discharge the burden of proof, this is what they require to prove, end of story. But it is possibly quite a brave move to do that without setting out some competing situation. But if I can just sort of, sorry, I'm struggling with moving slides. Go back. If I can raise just a couple of examples actually in connection with burden of proof. There is a case which I think was in 2020 in the English courts, where an arbitrator had decided something relative to burden of proof, and there was an application under Section 68 of the Arbitration Act to set aside the award on the basis of serious irregularity. And this was a situation where there was provision in a statute regulating arrangements between landlords and tenants of pubs. And this is a situation in the UK where you have what are called tied pubs, where the landlord is able to stipulate what sort of alcohol or what make of alcohol is stocked in these. And in this particular case, the landlord had required that 60% of what was stocked would be Heineken. So for the Heineken drinkers out there, that's probably quite a good thing. But the claimant who took this to arbitration said that this was unreasonable, and the legislation allowed a claimant or a tenant to have that dealt with at arbitration. The arbitrator decided in favour of the tenant and said that he did think that this was unreasonable, 60% was unfair, and actually replaced it, believe it or not, with the arbitrator's own view of percentage. But what was remarkable about that case was that the arbitrator decided to reverse the burden of proof. So to ignore what was in the legislation, which was that the tenant required to prove that this condition was unreasonable, and found that the landlord required to prove that this term was reasonable. And on that basis, this award was set aside. And I thought, you know, this is a reminder that actually you cannot just go off carte blanche as a tribunal and decide how to deal with burden of proof. What the judge did say was that it was open to the tribunal to do this, but they had to give the parties an opportunity to comment on that before making such a finding. So it's a reminder that these are important things and that they're not always as you assume. And the other one that I just wanted to touch on relative to burden of proof was in connection with construction cases where an owner or employer is seeking payment of what we would call penalty or delay damages. These are fixed damages per week or per month, where all that the employer or owner needs to say is the completion date has been missed by X weeks. The contract says I am entitled to so much per week. I do not need to prove anything more. And in that situation, the burden shifts to the contractor to prove that they're entitled to adjust the completion date. So that is another example of this shifting of the burden of proof. So perhaps a reminder that does happen. Now, there are also cases, for example, when fraud or bribery or corruption is alleged. There's been quite a bit of discussion about what is the burden of proof there. Does it shift quickly? Where, for example, some elements of behaviour have been proved by the party asserting fraud. Does the burden of proof shift to the other party to disprove it? This has been called the reverse burden of proof. It's also been called drawing adverse inferences. But I think, again, as a reminder that burden of proof can actually be a much more complicated situation than we might assume, and it's not always quite so simple as to say he who asserts must prove. For those of us who submit our awards to ICC for scrutiny, quite regularly ICC will say in their comments, did parties make submissions on the burden of proof, or were they invited to? And again, it's a reminder, I think, of what as a tribunal we probably should do. So if I can just move on to standard of proof briefly. Now I only have on the screen there a couple of options for standard, and the standard of proof as distinct from burden of proof, again, as I'm sure you know, is how much evidence, how much do I need to persuade the tribunal evidentially that my case is correct, that I'm to be believed. I think the general standard that we probably are most comfortable with is balance of probabilities. But that's not the only one that's advanced. Again, beyond reasonable doubt, for example, has been raised in some cases, again, where fraud, corruption are alleged. Another one that appears, and certainly in some Chinese cases, is clear and convincing evidence. And the view that that is probably greater than a balance of probabilities. So I think as far as standard of proof is concerned, it's useful just to ask oneself, depending on the nature of the dispute, what is the level of proof? Interestingly, I think this does become very tied up in weight of evidence. And I actually wonder how often we distinguish between the two, because we will be looking so carefully at what type of evidence we are dealing with. And I guess working out then, is that sufficient? Whether it's a whole combination of different types of evidence, but is it sufficient to get the party who needs to prove or evidence something over the line? And I've identified on this slide the RBA rules, as well as LCIA and ICC, who are very comfortable talking about the discretion that's afforded to the tribunal in determining admissibility, relevance, materiality, and weight of evidence. For example, it is entirely within the tribunal's discretion. Unlike the burden of proof issues, where there's far more silence, as it were, because I think it is a more difficult one to deal with. But just looking at the types of evidence, and Alex touched on that, one has had a trend, as we know, over the last few years, to move away from witness evidence or fact evidence on the basis that, for example, the ICC study spoke about the recollection of fact witnesses not being great, that more focus should be placed on contemporaneous documents. These are all parts of the scenario that I think a tribunal is faced with. I personally think that it would be very hard simply to rely on contemporaneous documents. I've had many situations where there have been witnesses given evidence as to why the contemporaneous documents do not reflect what actually happened. Sometimes people are put under pressure to record or not to record certain things that happen at the time, and that's where fact evidence or witness evidence is useful. The difficulty, unfortunately, is, as Renato mentioned earlier, we have created a monster in witness statements, where it is very hard to get to those parts of a witness statement which are actually direct evidence and in the knowledge of the witness. And I think that's regrettable. I'm hoping that, for example, the practice note and the appendix which Renato read out, which many of us now include as part of our procedural order number 1 in arbitration, will be heard by practitioners, and we will get back to a place where fact evidence or witness evidence has its place. But I think that really is my sort of brief resume of the sort of issues that I think as a tribunal we need to look at. Thank you.
Thank you. And we will take a question or two from the floor. Yes, please. It was the first hand, and then.
Hi, Jonathan Wood. There's been a recent case too in Griffiths about failure to cross-examine experts. How does the tribunal square that with what's happening before the courts? In that case, of course, the witness was not cross-examined. The rejection is court. How do we deal with that as arbitrators? Do you think cross-examination? I mean, under the bar, you have to put your case thoroughly in court and everything, but that doesn't necessarily always apply.
I can answer this through bitter experience. I was sitting in I was acting as counsel in a case in Sweden. So the procedural law was Swedish arbitration law, and the governing law was English substantive law. The tribunal was not, it was quite a long time ago, one of the members of the tribunal was English, but the chair was certainly not English. I assumed, given that we were in Sweden, that we did not need to put the case to the witness, because that is absolutely not the practice in Sweden. It doesn't happen. In fact, if you said to Swedish practitioners that you had to put the case to the witness, they wouldn't really know what you meant. So I didn't put the case to the witness in English ways, and the tribunal, in rejecting a certain amount of evidence, pointed specifically to the fact that the case hadn't been put to the witness, and therefore it hadn't been fair. And I was surprised by that, I have to say, but I also felt that I learned a lesson, because if you don't put the strict rules aside, if you don't put the case to the witness, then you run a risk, which is the whole reason for the rule.
And I think that's forgotten
Yes.
on many occasions when you're in an international environment.
It often doesn't arise, I guess, where you have experts meeting together in advance, agreeing what they can and can't. So I think in a way that would alleviate the situation. If none of that had happened and we were operating in a vacuum, it would be more difficult.
The problem then arises as to whether the witness is actually an expert sometimes. And, so you don't have, this lovely dance that we all go through, the experts meet and everything like that.
Yeah.
If you just have somebody who purports to be able to give evidence and they assume there's an expert nature, that process is pretty
Since that point has already been touched on before, could we just go back to that? Because it seems to me it happens quite a lot. Particularly you have in-house people who really are witnesses, but they say that they're also experts in an informal way on the technical issues. So they give evidence as witnesses, but in fact they're giving expert evidence. And it's very, very hard because that happens quite a lot. And then if you have a rigid tribunal, then there's all this issue about, but some tribunals just let it pass.
Yeah. Yeah, no, I think that's a very good point, especially in new technology. You will find that actually the clients know more than some experts, and that is a challenge. So to exclude it, I think, is unfair. Yeah.
We had one more question.
Hello, Manuel Penades from King's College and Arbitrator of my city. Just on that final point, actually, I just finished a hearing yesterday evening on a reinsurance dispute, and there were some witnesses by the parties, major insurance companies in London, and they had to prove they were appearing as witnesses, but at the same time got experts on the practice of usage in the market, and there was conflicting ideas or conflicting views as to what the practices were, and we had to discuss very much what the witnesses, what was the role of the witness in that case, and what was the role of the expert as to what the practice in the market was. But that was my question. It was just a reflection before what you comment, but my question concerns burden of proof, and also the role of the tribunal having discretion as to evidence. So I'll tie up to Alex's comment, because precisely in this case, there was a clause that said that the tribunal shall not be obligated, and I'm reading it, shall not be obligated to follow strict rules of law or evidence with a view to effect the general purpose of this reinsurance certificate. So the tribunal was not obligated to follow strict rules of law or evidence. So we had principal discretion to depart from those rules to effect the purpose of the tribunal, the purpose of the reinsurance certificate. And then the discussion was, among others, whether the burden of proof rule is something that parties can dispose of by agreement through a general clause that the tribunal can depart from a burden of proof rule simply to uphold what we think the parties agreed, or whether the burden of proof is something that is part of the due process and the fundamental rights of parties, that if the other part doesn't prove the case against them, the defendant should be free from the case. So it was quite an interesting discussion on the freedom that parties have to dispose of rules of evidence and how far the tribunal can go in exercising discretion to move from what is ordinarily the allocation of the part.
It's a very interesting point, and it occurred to me when Lindy was mentioning the pub case. What was the name of the pub case again?
Punch against Star Bars.
The Star Bars.
Yeah.
I think I'm right in saying the That was a case that went to the court on section 68, which is about procedural irregularity. It wasn't an appeal on question of law, because of the whole point being that you've committed a procedural irregularity, presumably even in situations where you have these general rules about everything being a bit relaxed in arbitration, which we saw also in the DLCA rules, for example, ICC rules and everything. It's more relaxed, but nevertheless, these fundamental requirements of due process.
That was one of the tensions in the hearing, whether if we do this literally and departed from rules of evidence widely, whether we could compromise the integrity of the arbitration award with a section 68 challenge. So that was one part that was feeling that it's complete blank check, just do whatever you think is appropriate.
I just wonder if that's stepping outside the tribunal's jurisdiction. Potentially it's when it ceases to be procedural and actually becomes jurisdictional, the role of the tribunal, because almost what you're describing is that the tribunal is to fulfill a different role.
But it's an interesting clause, so I want to add the comment on that, because I can see how a tribunal can be given discretion to depart from strict rules of evidence. I mean, in reality, you don't even need to put it into a clause. I mean, it's also in the Arbitration Act, basically, for example. But let's even assume that there is an agreement by the parties to depart from the burden of posting. But how can you say, how can you give an award in favor of a claimant, saying, oh, by the way, this part of the cause of action hasn't been proven, but nevertheless, or shifting the burden. I think that it's in practice, I find it difficult as a tribunal, whatever the abstract theory is, to come to a decision like that, because I mean, just as a matter of practicality, well, but I have the feeling that actually on this particular element of the cause of action, it would be fair to the other party to. It's quite different. It's where the tribunal has quite a lot of discretion anyway, I think. I think it's something that you touched upon. It's when there is some evidence on a topic, on one element of the cause of action. So, if there is zero evidence, I don't know. I mean, I find it quite difficult to see how you could decide in favor of that. But if there is some evidence, and then you have a discretion, I think, which is probably facilitated by clauses like that, to say, well, the claimant has put forward evidence. I consider, the respondent has not put forward any evidence in rebuttal, has not explained why it should not have been the case. Surely respondent maybe had, if this had been otherwise, respondent would have had some evidence in its possession, etc. And so you can use it that way. If there is zero evidence, I don't know.
Very good. I think we do need to wrap up. I'm so sorry. It is almost 8 o'clock, but I'm amazed to see the enthusiasm at 8 o'clock when it is of evidence in construction. So thank you so much, everyone. Thank you. Big applause to our panelists.